Mr. and Mrs. Olley took a room at the Marlborough Court Hotel. They paid for the first week and were given the key to their room. Inside the room, on the back of a door, was a notice containing 15 different terms and conditions, the first of which read, "The proprietors will not hold themselves responsible for articles lost or stolen unless handed to the manageress for safe custody. Valuables should be deposited for safe custody in a sealed package and a receipt obtained." At the hotel, when guests were absent, they would leave their key in the reception area on a hook marked with their room number. One day, the Ollies did this, and while they were away, a thief entered the hotel, took their key from its hook, and stole some valuables, furs and jewellery, then simply left. There were a number of questions before the court, but for our purpose, the important question is whether the exclusion clause on the back of the door provided any protection for the hotel. Lord Denning held that it did not, for two reasons. First, the provisions were not actually seen by the guests until after the contract had already been formed. And second, there was no evidence that the provisions were ever actually accepted by the guests. Lord Denning said, "Notices put up in bedrooms do not of themselves make a contract. As a rule, the guest does not see them until after he has been accepted as a guest. The hotel company no doubt hope that the guest will be held bound by them, but the hope is vain unless they clearly show that he agreed to be bound by them, which is rarely the case." However, he did say that if the notice had been provided before contract formation, it would likely have been effective. He said notice could be given to a person by handing him before or at the time of the contract a written notice specifying its terms and making it clear to him that the contract is on those terms. A prominent public notice which is plain for him to see when he makes the contract or an express oral stipulation would no doubt have the same effect. From this case, we confirm that provisions can be added by notice, but fair notice must be provided before the contract is formed.